Well, hello everyone. Thank you for joining us on this Monday morning here in Europe, or Monday afternoon or evening if you're joining from elsewhere. Thanks to everyone for coming along for this rapid response roundtable discussion on the ICJ climate change advisory proceedings, which saw its 2-week oral proceeding finish on Friday after seeing dozens of presentations by states and international organizations. My name is Mike Becker. I'm an assistant professor at Trinity College Dublin School of Law, as well as a co-convener of the ESIL interest group on international courts and tribunals. I'd like to thank ESIL up front for helping us to organize this event on relatively short notice, as well as the Trinity Research in Social Sciences Institute for their assistance today. And before I introduce our terrific roundtable panelists, I just wanted to spend a couple of minutes to frame today's discussion. Many of you will know that these ICJ proceedings are the result of an advisory opinion request that was put to the court by the UN General Assembly back in March 2023. And that request, which was spearheaded by a group of students at the University of South Pacific in Vanuatu, contained two very broad-ranging questions, which I'm just going to paraphrase here to remind everyone what this advisory opinion case is about. So the first question, what are the obligations of states under international law to ensure protection of the climate and the environment from greenhouse gas emissions from states for present and future generations? That was the first question, paraphrased. And then following on from that, the second question, what are the legal consequences where states have caused significant harm to the climate system with respect to states or to peoples or to individuals that are injured or especially affected or are particularly vulnerable to the adverse effects of climate change, including small island states? Big questions. Now, unlike a contentious case at the ICJ, advisory proceedings are open to all UN member states and to a broad array of international organizations. And these proceedings have been record-breaking in this respect, with over 100 states and organizations participating, either by making written submissions or appearing before the court over these past 2 weeks. And that brings us to today's roundtable. Since drawing on some of the language from the Paris Agreement, this seemed like an appropriate moment for something like a stock take. What have we learned from these 2 weeks of oral proceedings, these numerous half-hour presentations to the court, which are, of course, backed up by thousands of pages of written submissions? What lines of argument on different sides of these issues did the proceedings help to crystallize? And what issues or lines of argument in particular got a lot of attention, but also perhaps what issues deserved more attention or didn't get as much attention as one might have expected or as one might think they should have gotten? And I'm also hopeful that this discussion today might shed light on some broader issues, which goes really to whether the participants in this case have managed to strike an effective balance between, on the one hand, talking about the gravity of the problem, the injustices associated with climate change, but on the other hand, actually providing a roadmap that sets out how international law, as it exists right now, not necessarily as one might wish it to be, provides concrete answers to the questions that have been put to the court. So luckily, we have an absolutely stellar panel here to talk through these issues. Professor Carolyn Foster is Professor of International Law at the University of Auckland in New Zealand. Many of you will be familiar with her path-breaking work on scientific evidence before international courts and tribunals, her work on due diligence standards, and so forth. We have Danilo Garrido, a Brazilian qualified lawyer, senior scholar at Wadham College at Oxford, who also serves as legal counsel to Greenpeace International, and Dr. Corina Heri, who's a postdoctoral researcher at the University of Zurich, where she's the co-lead on the Climate Rights and Remedies Project. Corey's work on climate change litigation at the European Court of Human Rights will be familiar to many of you. And she was also one of these brave souls who managed to provide real-time coverage on social media of significant portions of the advisory proceedings over these past 2 weeks, which was really a very valuable service to those of us just trying to keep track of what was happening. I should also mention that all of our panelists here today have been involved in some capacity in advising one of the organizations that appeared in front of the court, the International Union for Conservation of Nature. But I believe everyone here is speaking in their individual capacity. So our plan is to spend around 25 or 30 minutes on substantive issues relating to the proceedings. Then we want to spend a little bit of time on some procedural questions, and then we will open it up for Q&A. So those of you in the audience, we have around 100 people attending the roundtable right now, which is great. You can submit questions through the Q&A feature. And my ESIL interest group co-convener Cecily Rose has also joined us, and she will help me to sort through those questions and put as many questions to the panelists as we have time for. So with that out of the way, let's get started. What have we learned from these 2 weeks? And I guess I'd like to go to each of the panelists and start out by asking, what did you see as some of the main lines of argument that emerged? Who was making them in terms of state groupings? And were there issues that should have received more or less attention? So maybe we could start with Professor Foster.
Thanks, Mike. Hello, everyone, and congratulations to the interest group for convening this very timely webinar. Mike, just to clarify, would you like me to perhaps give a general sense of what we've learned, and then we can talk about particular issues after that?
That sounds great.
Okay, well, look, I think one of the key things that we learned was that states are continuing to appreciate the significance of 1.5 degrees C and the language of rapid, deep, and sustained emissions reductions that was adopted in the global stocktake decision. That's being echoed by a good number of states. Certainly, all states are taking climate change seriously. And what was seen in the oral pleadings also confirms that both treaty and customary international law are seen as relevant pretty much universally. I'm not saying they all consider that both apply, but they're certainly seen as relevant. And so states are taking the customary international law obligation around no harm and prevention most seriously, and we might say more about that in a little while. And nearly all agree in general that the international law relevant to climate change embraces law from different fields. Again, there are some standouts here. And I suppose one other thing that we've learned, which is more on the negative side, is that no state is linking what is happening before the ICJ to what is happening in particular in world trade law. And given that the necessary collective measures most certainly include major renovation in that area, this is something that is really lacking from the dialogue here. Finally, I guess most states are seeing the law on state responsibility as probably relevant here for the second part of the question, again, with a few exceptions.
Very good. That's a great way to start things off. Maybe I'll go to Danilo then to answer the same question, really. Where do you see things after these first 2 weeks?
Yeah, first, as Caroline was mentioning, thank you very much for convening this great event. So essentially, I think based on what we heard, we can roughly divide states in two groups, high-emitting ones being more conservative and trying to evade obligations and legal consequences, low-emitting ones on the opposite end of the spectrum. And I think that the focus of this first group, one of the focuses was very much on limiting the applicable law to the three climate treaties, and especially to the Paris Agreement, either by saying that they are the only relevant source, or even if they say it's the primary source, they are not fully acknowledging the obligations under customary norms and the other treaties, which is something that's more nuanced in the position of other states that argue for those treaties as the primary sources. I would also say quite an interesting point was on causation. It was quite well, perhaps unsurprising, but still disappointing that high-emitting states were arguing that establishing the causal links between state conduct and climate harm was way too complex. They were casting doubt on attribution science, and essentially saying the court should not go anywhere near this for the time being. But there were some exceptions from the high meeting groups on this point. I think Brazil is a good one that was saying that there are already scientifically backed methodologies to quantify and attribute historic emission to states. Brazil is problematic on current emissions. And yeah, I think my final point on what I would have liked to see more from these proceedings, I didn't really see a framing around an obligation to refrain from contributing to the destruction or the extinction of other states. Um, yes, there was a lot of on transboundary harm, but not on the actual destruction and what sea level rises might imply for statehood. And also whether greenhouse gas emissions could cause sea level rise, that are causing sea level rise could amount to use of force potentially against the territorial integrity of ISTS. So I think those are my 2 cents for the time being.
Corey, over to you.
Thank you so much. My understanding of what we've seen in the last 2 weeks aligns in largely with what we've just heard. I looked at these proceedings because I work in human rights law. I looked at these proceedings, especially kind of hoping for engagement with human rights law, which I think has to play an important role here. So I'd like to say a couple things on that, and maybe a few general things in advance. So in terms of the positive things, I also think we need to maybe be aware of the fact that it's quite unusual or quite welcome to see so many states taking the floor and arguing that customary law does apply and that the customary no harm rule applies to climate change or to emissions, arguing that the Paris Agreement doesn't exhaust and the UNFCCC don't exhaust the obligations of states and so on. So seeing that so often, I think is very good news. In terms of the not so good news, also, as we've heard, there were a number of states, especially high emitting, highly developed states, that were very focused on limiting their obligations, very focused on excluding historical emissions from any kind of discussion around reparations, and also focused on making sure that customary obligations don't apply along a sort of backward-looking temporal axis. In terms of, like I said, human rights law, which was the sort of lens that I was looking at these proceedings at, it was quite interesting, the discussions that were being had about the right to a healthy environment on the one hand. And there were a number of states that were arguing that this right has now crystallized into customary international law since the UN General Assembly recognized it in 2022 in a non-binding but still very important declaration. And then there were also discussions about a wide range of other rights. And here, I think one thing that is maybe inherent to these proceedings is that victims of climate change are not directly participating in these proceedings, with a few exceptions. So, for example, the Netherlands ceded some floor time to a youth representative. Some, especially organizations, really tried to make this part of their interventions, and some states also really focused on showing what the actual impacts are, showing video footage, showing photos, and so on. But still, this was mostly states and international organizations discussing the situation. So one thing that I think for me was maybe a little bit missing was that perspective. And another thing that I kind of thought was missing was the Convention on the Rights of the Child, which of course was not part of the question that was asked to the court, but which I think is incredibly significant in this context. And I'd be interested in talking more about why and how. But for present purposes, I think maybe that's enough of a first reaction. Thank you so much.
Great. Well, lots of issues there. And my takeaway from this is that we didn't really see maybe much of a surprise in terms of what states were playing down any kind of historic responsibility or were urging the court to stay away from causation issues and so forth. I mean, it seems like this played out in ways that might have been widely expected with traditional greenhouse gas emitters, and the states potentially most liable for the costs associated with climate change, pushing the court to do nothing, or do very little, and the states that are likely to be suffering the impacts that Corey just described, urging the court to take a different or more proactive approach. So that's probably not that surprising. One of the points we'd put to you in advance was, were there particular presentations by individual delegations that stood out to you for one reason or another, good or bad or something else? So maybe we could go around, and if you want to highlight what you saw as some of the significant interventions, and significant in any sense of the word. Maybe we'll start again with Caroline, but I'd encourage, if any of you want to respond to each other, certainly feel free to do so too.
Yeah, thanks, Mike. I mean, I would love to mention a couple of interventions, but I'd also love to say a little bit more about customary international law, because I think maybe some of those on the webinar might be interested. So shall I start with that, and maybe we can circle back to me later about my chosen interventions.
Absolutely.
Yeah. So really, as Corey was saying, the customary international law was so thoroughly present here and in an environmental context. And I guess we had the advisory opinion on nuclear weapons. It's a couple of decades or more ago now. And then we've had those bilateral environmental cases. So here we are back in the multilateral context and really testing this rule out. And this is the area where states, I thought, worked hardest to try and get some strong legal arguments on the table. And this is an area where the court will be working solidly through those legal arguments. And it's going to have to, we hope it will give views on these different arguments. And not all of the arguments can be winners. So most submissions did say that the customary international law no harm rule and/or principle of prevention applies. But there were then perhaps 5 different objections to the application of the rule, and they were quite distinct. So the first one seemed to be around of views about how long the rule has been in existence for. And there was some lovely rebuttal, if you like. I think Germany may have been one of the states that said the rule was not in existence at the relevant time. But there were sort of other states who suggested that there's a challenge here. Korea said this issue poses an acute challenge, and Canada pointed out the rule does have to be in existence at the relevant time. But there was a lot of pushback. Vanuatu notably, of course, speaking first, drew our attention to the Alabama claims, which would be really where this law starts to form. And Costa Rica made a really good argument too, saying it stems from the character of states as sovereign entities. So essentially it's been around as long as states have. That was the most far-reaching back in time intervention. So there's good arguments on the table there. Now, the second objection was around the principle of prevention or the no harm rule not applying because the situation is different to the bilateral ones between physically neighbouring states. Lovely pushback there, in particular from Kiribati. Greenhouse gases are like smoke, and greenhouse gas and smoke are both like fumes, or are types of fumes, as in trail smelter, and plenty of other pushback too. The third argument was that states need to be aware of the risk of harm in order for this law to apply. So what have states known about the risk of harm from greenhouse gases at various times? And there were some lovely arguments that this has been known sufficiently from at least the 1960s. And that's actually where one of my favourite interventions came in, because the state who decided to include evidence of this in their oral submissions which one was that? Barbados, I believe. So some lovely pieces of evidence from the 1960s and 70s, US National Academy of Sciences through the Bundestag, and many more on the way. The next objection was that some states seem to be arguing that we couldn't apply the rule without evidence of state practice and opinio juris establishing that the rule could apply in relation to greenhouse gases, which seem to be Germany, Australia, Canada, and the UK, and Korea also saying the court needed to take care here. So those were the main objections. And then there were two states or groups of states who sought to, I guess, consolidate doubt around the applicability of the rule. So the US saying there was a lack of consensus about its applicability, and the Nordics questioning whether, in light of all of these factors, we can apply this rule. And then you had the two extreme positions as well. So the argument that greenhouse gas emissions are just not regulated by general international law and are not conventional environmental pollution from China. The UK also arguing that greenhouse gas emissions are not covered by the prevention principle. But on the positive end of the spectrum, we had a lovely intervention from the Netherlands arguing that there is a specific, as I understood it, a specific preventive customary international law rule relating to greenhouse gases, with an obligation to develop, adopt, and implement a mitigation policy that is passed into general international law, and indeed, the Netherlands argues, is an obligation erga omnes. So really meaty stuff on customary international law, wonderful work for the court to do, and we'll see what they say.
I think it's so important that you highlighted that, Caroline, because for me, one of the issues with the questions posed has always been the fact that, well, how is the court going to get a handle on this when, if we're focused on treaty obligations, every single state has a slightly different set of obligations. We have differentiated obligations across international law. So it seems very important that if the court ends up anchoring some of its key conclusions in customary international law applicable to everyone, it maybe goes some distance towards dealing with that concern that I had or that some others might have had about the nature of the question in the first place. All right, do any of our other panelists want to come in to respond to any of that, or maybe to highlight some of the submissions that made a particular impression on you over the past couple of weeks? Maybe Danilo?
Sure. Yeah, and I mean, fully agree with the analysis that Caroline just made on customary international law, and yeah, it was quite pernicious to see some states trying to argue something that, being party of the Paris Agreement and the lex specialis argument would mean that their obligations under customary international law were not applicable anymore, which makes no sense at all. But hey, they were trying to play with the cards they were dealt with, I guess. Yeah, I think two states that I would like to highlight are first Samoa. I think they articulated so well the problem of lex specialis and the centrality of the Paris Agreement. And yeah, to see that from Pacific state, and with Counsel also wearing Pacific garments was quite refreshing before an institution that's often marked by English barristers and French professors. And the other one that I would highlight, but in a negative way, is Switzerland. To me, it was quite clear that they are on a journey to undermine the Klimaseniorin precedent in every possible fora they can. And it was quite a stark contrast to other states that were really celebrating the findings of the European Court on that judgment. So yeah, those are my 2 cents.
Yeah, that's really interesting. I think probably many of us would have anticipated seeing Klimaseniorin and other important climate change cases being used to try to support arguments pushing the court to reach certain conclusions. And as you point out, there's another side to the coin there. The states might actually be seeking to use the ICJ proceedings to undermine or push back against decisions that national or regional courts have made. Corey, what did you think? You who watched everything so closely for at least most of the 2 weeks.
I did my best, but it was challenging, I have to say. So I also have a few positive ones. One that really stuck out to me was also Barbados. They covered some topics that I didn't hear other states cover, that I hadn't really thought about before, like insurability, for example, and the ability to rebuild after extreme weather events. A positive one for me too was Albania and the discussion on intersectionality that they had. Colombia, Portugal, those also stood out to me. The ones that stood out negatively, I have to start as well with Switzerland. And I can only underscore what Danilo said, that Switzerland was clearly trying to sort of undermine Klima Signorinen in every way that it could. And that stands against the last months where in the domestic setting, there's been so much pushback against this ruling and also against the court that issued it and its legitimacy. So very problematic. On the other hand, a lot of states mentioned this case in a positive way, as Danilo also said. There's a graphic from Sebastian Deuk where he shows that this case in just the first week or something like that of the proceedings was mentioned like 45 times or something like that. And most of those references were to use it as an authority that recognizes the link between human rights and climate change, and so on, that uses science in the context of legal analysis and so on and so forth. So positive mentions. Two more that go to what you just said about undermining international courts would be Russia and China and their attempt to sort of question the ITLOS advisory opinion. And the last one would be Germany, because Germany tried to limit the scope and the content of human rights law by arguing, and I have the quote here, they argued that, quote, states fulfilling the Paris Agreement thereby simultaneously fulfill their human rights obligations. So that's that idea that we just level human rights law down until it's asking for nothing more than the binding obligations in the Paris Agreement, which is very problematic. So yeah, those would be mine, and I think they tie in very nicely to what was just said. One last one I would mention, actually, that I was thinking about when Caroline was speaking, is that Belize actually very clearly set out all those objections to customary international law and tried to and very nicely actually countered each one, really as a response to the written statements of the other states. I thought that was very, very interesting to see as well. They were engaging so clearly with what was being argued by the others. Yeah, but that will be my list.
Yeah, and a shout out there to Albania. They were one of the few states, I think, that really talked about gender equality. I noticed also Mexico, Nepal, and Pakistan, and that the Cook Islands put the president of the National Council of Women up to speak, which was great. Yeah, but I think my vote really for the most powerful presentation would probably go to Vanuatu, who, as we know, spoke right at the beginning, and for many reasons, but partly also for the argument on self-determination. So referring to the severe, systemic and sustained violations of the right of peoples to self-determination and to determine their own fate that are accompanying climate change and will obviously continue to do so. I also love the argument from Kiribati that there is an obligation to cooperate to ensure self-determination that operates at a number of different levels, and underlining that self-determination is an obligation erga omnes from Namibia and Micronesia and Tuvalu, and also Liechtenstein was quite active in this area as well. What was quite intriguing actually was with respect to permanent sovereignty over natural resources, because that can be played in a couple of different ways here in the context of climate change, of course. So it can be played from a self-determination perspective and from the point of view where states are arguing that respect for states' existing territory and maritime spaces should be ensured in the future. Perhaps even Vanuatu argued as a matter of reparation. So permanent sovereignty over natural resources in that sense, but of course at the same time it can come up in the context of fossil fuel production. I think Kuwait may have used it in that context. So that was generally played less strongly, although it was present, than self-determination per se. And there are lots of arguments around statehood as well. But yeah, Vanuatu was extremely powerful, wonderful advocacy, and self-determination was one of the strong features there.
Well, I think that's all very helpful. And for those of us who will be going back to the proceedings trying to figure out what's happened, I think keeping your comments in mind gives a lot of us a sense of what to look for and what to try to pick out among the different arguments that have been made. I'd like to turn to this set of questions relating to procedure that I asked, but in part because I think that the the line between the substance here and the procedure is very blurry. And what you may have to say in response to some of the questions we put to you about procedure will bleed back into the substance very easily. So there's maybe no reason to keep them so separated. And I wanted to also welcome my ESIL interest group co-convener, Yusra Suedi from the University of Manchester. We had some technical problems getting everything set up. So we're glad to have you with us as well, Yusra. And Yusra, who was also involved in the submission of the IUCN before the ICJ, but also is here in her individual capacity. So, Yusra, you should chime in here as a both co-host and co-panelist, if you want to think of it that way, talking about some of these procedural questions. So I wanted to hear people's views on kind of from a big picture perspective, whether an advisory proceeding involving 100 plus participants. I mean, we tend to kind of celebrate this. This is great. We're seeing a lot of interest and engagement with the process. But at the same time, what does that mean in terms of effectiveness? Is this an effective way to address such a complex issue? And I think the discussion so far has already revealed that there are many, many different strands of legal inquiry to go down here. So is this effective, especially maybe when the court has been asked such broad-ranging questions? So I was curious to hear from all or any of you. Did it seem to you like participants had, to some degree, coordinated their interventions? And if so, how effective was this? Did that seem to work? And then I also was curious, and you should feel free to address any of these points. You don't have to address everything. Is there anything the court could have done to organize these proceedings a little bit differently? So, for example, some observers, and this includes me and Cecily, who's also here on with us, we, for example, wrote something a little bit critical of the fact that the court had decided to meet with IPCC scientists in a closed meeting in advance of the hearing. This struck us as something that was well-intentioned, but maybe wasn't the best way to proceed from a substantive justice perspective. So, for example, why not have climate scientists testify or be part of the formal proceedings? Would that have been useful? But maybe more interesting, and this is where we really go back to the substance, I think, it was really fascinating to me to see 4 questions posed by judges at the conclusion of the hearing on Friday, in part because those questions themselves are remarkably broad in scope. And I would suggest that any one of those 4 questions could itself have been the object of an advisory opinion request. And I wonder what that says about the proceedings as a whole, that such kind of core important questions needed to be posed at the end, suggesting that they hadn't really been sufficiently addressed, or at least not by enough states during 2 weeks of hearing. The big questions from Judges Cleveland, Tilati, Orescu, and Charlesworth. So I'm very curious to hear, I've thrown out a lot there, if anyone has reactions to any of those points. Anyone want to come in first on that?
I'm happy to.
Thank you, Carolyn.
Yeah, it was a fascinating phenomenon, wasn't it, to see so many submissions in such a range of topics, and to me, it did seem appropriate to the proceedings. So I did actually think that this was a very good element of these proceedings, and I really recommend, that people take the time to read some of these submissions. In terms of coordination, very aware that the Pacific Island and Caribbean states coordinated with, a number of different meetings. And this is very helpful, especially if one allocates speaking subjects between different participants. So, for instance, Vanuatu did not have to address every issue, even though together with the Melanesian Spearhead group, they were accorded more time than the other states. It still would not have been possible to achieve the same advocacy if they had to address all the issues. So that worked very well. The opposite, I think we saw with the Nordics in a way, where the 5 Nordics took the 1 speaking slot, which probably was better advocacy because it saved repetition at the same time as giving more weight to their statement. Yeah. As to the scientists, yes, that would have been a hard call for the court. I saw what the 2 of you had written recently and have been pondering on the issues. But imagine imagine the time-consuming burden if states were realistically to participate in the court's interaction with the scientists and some of the resourcing challenges, and also how this might slow down proceedings if it were taken very seriously on a topic on which there is certainly no time to lose. I'll leave it there for now.
Maybe I can go next.
Please.
Yeah, so I mean, second everything that Caroline was just saying. And I would also like to highlight how diverse these proceedings were also in terms of the voices that we were hearing. It was not only lawyers and state representatives, some delegations like Vanuatu, like the Pacific community, also dedicated some of their minutes, precious minutes before the court to activists, to especially those that were leading the process from the beginning. So I thought that was quite a shift from what we're accustomed to at the ICJ, almost turning into more of a political fora in some ways. But I think that that's a welcome thing, to be quite frank. I also agree that there was definitely coordination. For one thing, the Pacific and the Caribbean states, they did organize write shops and speaker shops in the lead up to this to really pool resources and bridge the capacity needs they had. And I think this also translated into the fact that a lot of the Pacific states specifically were using um, multimedia presentations, were giving their platform to activists, as I was mentioning, and to people impacted by climate change. Those were all deliberate decisions from what I heard. And yeah, same thing can be said about the high emitting states with the Nordics, but also if you see the lines of arguments, you can definitely see that they were speaking to each other in the lead up to the written proceedings and also to the oral proceedings. On the point on the meeting with the IPCC scientists. So this is something that it's not new for the court to do. It's part of its Article 1 prerogatives under the rules of the court. And to be quite honest, I think that is the way that should happen when it comes to scientific evidence, to have it in full court. Even though it would be extremely beneficial from a transparency point of view, I do think it hinders the ability of the judges to ask questions and to make it more of a dialogue. So that's my yeah. I think I was, to me that was the lesser of two evils, to be quite frank. And if there was any other things that I think the ICJ could have done to organize its proceedings, I think it's something that in coming years we might see more push, but civil society presence before the court would have been welcome, especially in this case that was literally originated by a civil society organization. How that could work, the need to change and amend the rules of the court for that to be possible, those are questions that hopefully the court will grapple in the coming years. But to me, it was yeah, quite stark to see the blockage that a lot of civil society organizations had in engaging with the court throughout these proceedings. And I'm speaking also on behalf of Greenpeace here.
Can I press you on that a little bit, Danilo?
Yeah.
What's an example of something that you think an NGO or a civil society would have been able to bring to the proceedings that wasn't brought, channeled through one of the state participants or one of the international organization participants? Or is it simply a question? Is it more kind of a symbolic question of recognition?
I think it's both. For instance, the argument that I said earlier in this webinar that I thought was missing on use of force, greenhouse gas emissions as potential use of force. This is something that we developed in the Greenpeace submission. That's of course not part of the official proceedings of the court. And it's something that I didn't see. So there are interesting arguments that perhaps because they are more progressive, they are more tentative, some states might be wary in making, but perhaps a civil society organization can do. And on that note, there is precedent for civil society organizations to be authorized to participate in proceedings before the court from the South of West Africa case. So it's all a matter of interpretation of what international organizations mean under the treaty. Sorry, under the ICJ statute. But that's for another
You're getting
discussion.
into controversial ground there, Danilo. Okay, Corey, over to you.
Thanks so much. So I'd like to tie into something that Danilo said also about the scientific experts, and having read your post with Cecily about the phantom experts. I think describing this as the lesser of two evils, the way that the court went about this is a very nice way to describe it, because I think having this kind of presentation from scientists in as part of the public proceedings would have not served the same purpose. I don't think, and I think you speak to this in your blog post as well. I don't think judges would have as freely been able to ask questions, including sort of silly questions or basic questions that they would be able to ask in the context of a closed hearing. So to really understand the fundamentals and things like that. And one thing I think that's also relevant to mention is that states already get to participate in what the IPCC does. It's an intergovernmental body, so they're already involved there. So this is I think that's also something that kind of maybe to some extent heals the fact they weren't able to be part of this this hearing. In terms of coordination among participants, I think it was impressive and special and commendable to see the way that especially the small island developing states presented what is happening to them and what is happening around the world. It was really very powerful and clearly coordinated in terms of the way, as Danilo described, the arguments, the expertise, and the issues were sort of spread out across the interventions. One thing that struck me in sort of the opposite direction was the UK. And the UK, clearly it was listening and responding to the arguments of some of the other highly developed high emitters, but it was kind of trying to almost distance itself from the US and Russia and China and so on, and almost reprimanding them for their arguments, while at the same time, of course, not making a particularly progressive argument itself. But really interesting to see that it didn't seem to want to be in the same boat as those states. The Nordics, I think, were also interesting. So to me, the Nordic intervention sounded more like a Norwegian intervention with more states added in. And so I wasn't in the room when those decisions were made, but I would be very curious to see what the thinking behind that was. Yeah, this would be, I guess, some of my initial thoughts, and also maybe to really reiterate what Danilo said, that I think broad-based participation of Indigenous peoples and NGOs and civil society, I think that's not something that can be replaced by states, even though the efforts that were made, some of them were commendable. Others I am not entirely sure about yet. Speaking here about the Dutch sharing a floor time with a youth representative, where I think we always have to be critical of those kinds of initiatives when they come from highly developed states with high historical responsibilities, because I think there's always a risk that we're greenwashing when something like that happens. But yeah, I think those would be my initial reflections. Thank you.
I don't know if Yusra, if you want to comment, or I also wanted to maybe put it to Caroline. What did you think about the big questions asked at the end, though? I mean, these are such big sweeping questions. I don't know, does that speak to some flaw in the proceedings that these weren't already addressed by parties?
Yeah, thanks, Mike. I didn't particularly think so. I'm mindful that sometimes judges ask questions in order to be helpful to clear away doubts that they may have, in order to be able to proceed and feel that all matters have been, states have had a chance to address all matters. Perhaps the most challenging question is the fossil fuel question, and that one, it really will be interesting to see what is said further about that matter.
And that was the question from Judge Cleveland, the judge of U.S. nationality. Yusra, I know you had some thoughts on the proceedings as well.
Yeah, thanks, Mike. So in terms of, I just wanted to say that I find the coordination fairly impressive in light of the very, what I consider to be a very broad question that was asked, and that touched on a multitude of different sources in international environmental law and elsewhere. So I think all of that considered, actually, I think that the states and organizations did a pretty good job at making sure that there was significant overlap on what were the key issues. In terms of the procedural question that you raised, I think something to add to what Danilo said is the question of whether the court can, in fact, bring in experts in the advisory context. And I think while there might be some misunderstanding about that, my personal take is that they absolutely can under their rules. So using Article 68 of the ICJ statute as some kind of an umbrella clause to kind of use contentious procedures in the advisory context, which is possible. The court has only used that maybe once or twice, is very shy about it. In nuclear weapons, did not take the opportunity to do that while it could have. So that was absolutely possible here. Yeah. If Mike, you agree, should we move to the Q&A?
Yeah, I think we should go to the Q&A. So I know Cecily is carefully monitoring the questions that have come in from the audience. So maybe we can try to get to some of those now.
Yeah. So I am seeing a couple of questions having come in. Thank you to everyone for having submitted your questions, and you're very welcome to keep submitting them as we do have some time remaining for this part of the webinar. So there was one really great comment by Peter Nuttall, but I do want to turn to the question by Stephen McLean. And he says, based on what states and international organizations have submitted thus far, will the opinion end up having an impact before domestic courts? And if so, what type of impact would that look like? And he did not specify who he would like to answer that question. So I assume anybody who wants to answer it can do so.
I suspect we might have complementary answers, so maybe several of us might speak. There's also, I noticed a question in there that maybe will be coming up about future generations if we do have time. But just on the domestic courts, I know that others will have a lot to say about this, but relatedly, I do think it's interesting how low a profile Article 4, Paragraph 2 of the Paris Agreement had here across the oral submissions, which is the provision that requires the parties to pursue domestic measures with the aim of achieving the objectives of NDCs. I know the IUCN took a strong and sensible position here that such measures would need to be necessary and timely and meaningful and effective. But we have yet to see authoritative articulations of what this provision really means, and that would be something that it would be good if the court did say something about, and would be extremely useful in domestic proceedings. I did think Latvia put it very well when they said that domestic measures must be for the purpose of achieving such contributions, i.e. the NDCs, and bear a reasonable relationship to the parties' stated objectives. And the UK actually also said that parties must intend to achieve NDCs and pursue appropriate targeted domestic measures. And that word intend is fascinating. Reminds me of the whaling in the Antarctic case for the purposes of scientific research, and how that enabled the court to establish what we might call I think they called it a standard of review. I'm not sure whether I might call it a regulatory coherence test between the objectives of measures and the content of those measures. So this is all important ground and ground where domestic courts will be very active, and perhaps the court may indeed say something that would help that process.
Any other responses? Reactions?
Corey?
I feel like we had an order going and it was working very well, so I don't want to break it. But I just wanted to jump in and say that, I think it's always difficult to tell what the impact domestically will be of a ruling like this. Depends very much on legal traditions and access to courts and sort of many things. But what we're seeing, and I think the Klima Signorinen judgment, even though it's very different in many ways, and it's a contentious judgment against one state and a regional system and many other differences to these proceedings, I think we see that there's a general shift of tone going on, and that rulings from regional and international courts really can contribute to that and really can take some options off the table, some of the probably very worst interpretations of the law. So even if they don't answer every question in detail, they do, I think, make a very important contribution in that sense. So the same way that Klima Signorinen took the option that human rights have nothing to say about climate change off the table, I think the ICJ has a lot of opportunities to do something similar in a lot of areas of law here. And so I think it could have tremendous impact, of course, depending on what the opinion actually ends up saying. I think when we talk about things like impact and success of judgments, those are such sort of many layered and textured discussions, and they have so many aspects. But I think it's fair to say that the rulings that we've seen so far, and also the opinions that we've seen so far, they very much are having impacts on how these discussions are held. The ITLOS advisory opinion, for example, was mentioned so many times. I don't have a count, but I saw one that said that it was mentioned almost 300 times in just the oral stage of these proceedings. So we see that there's very much a dialogue across various courts and tribunals happening here, that they're mutually strengthening and reinforcing each other, and again, taking sort of the worst options off the table. That will be my initial weigh in. Thanks.
So a couple of more questions are flooding in now. Perhaps, unless, Caroline, there's something you would really like to weigh in on with that question, I can
You know
move
what?
on.
I would just like to point out, Yusra, that I think one of the most valuable aspects of, I mean, I think there are some people who are very skeptical about the value of the advisory opinion
Yeah.
proceeding in general. And I have some sympathy for some of the concerns about that. But I do think that probably its greatest potential to have impact will be in how, whatever the court says, those little pearls of wisdom from the ICJ can then be picked up in domestic litigation and used to shape binding judgments, binding on national governments. So it'll be really interesting to see if the court produces those almost like sound bites that can be picked up in domestic litigation.
Yeah, absolutely. I think that's the hope that was actually expressed by a number of states, particularly in their written pleadings. So we have a question from Anne Van Aken. Just to get a hunch, how do you think the court will navigate the legitimacy question, given, for example, the backlash against Klima Signorinen in Switzerland? Will it come down in the middle somehow? And if that's so, what would be the most likely fault lines on the second question, because this is what ultimately matters to the rich emitters?
Thank you, Anna, for the question. I know that probably Corey and Danilo will have different answers to me again. So a few thoughts. Look, that is a question that was probably running through all our minds as we progressed through the submissions. You know, what's the lie of the land here? How's the debt going to be cut in a way that is persuasive, makes an important contribution, and doesn't cross really difficult lines or take the court into territory where its views might be harder to support. Obviously, we will be hearing quite a bit about the Paris Agreement from the court, and one would hope, in conjunction with a duty of cooperation, that will all be legitimacy enhancing for the court. On customary international law, we are likely to hear a well-reasoned legal response from the court, which will cover important new territory and should, on balance, absolutely be legitimacy enhancing. We may even see stringent due diligence adopted, the standard articulated by the ITLOS, which a number of states put forward. And that, of course, is a fairly open-ended variable standard due diligence or stringent due diligence even. So, you know, that's opening territory. That shouldn't be problematic. It should be legitimacy enhancing. the question in a way is, what are the necessary and appropriate measures under customary international law? We can look back to the Paris Agreement for much of that, but not all of that, and important arguments were made to that effect. Again, it's open-ended, probably not going to be a legitimacy issue, but will make ground. There are some areas in the human rights arguments, which Corey may be well placed to speak about, where the court will be looking carefully at states' submissions regarding the extraterritorial application of human rights or not, regarding the emergence of a human right to a healthy environment, and the stage we're up to with that, and how the court handles those issues will be important for its general status and position. And future generations, I'll bracket for now, but I did see right at the outset we had an important question from our listeners around that, and I'm hoping maybe we could come back to it.
Right. So a couple of other questions that have come in. There's one from Surya Roy, picking up on the submissions by Barbados and Belize and Vanuatu mentioned by the speakers. Were all the low-emitting states of the same mind, and were there any high-emitting states that sided with low-emitting states? That may have already slightly been touched upon. For the purposes of time, I'll perhaps read out 2 or 3 other questions, and then you can decide which ones you would like to respond to. So, Francis,
I think Corey was going to speak to the human rights issue as well. I didn't mean to.
Of course, no problem.
In that. Yeah.
Please.
Sorry, I think Danilo maybe wanted to speak as well. I'll just be really quick because I know we have many questions and there's so much we can talk about, but I find this particularly interesting. So I wanted to go back to Anna van Aken's question and just say that, of course, this is, I think, on every court's mind when it's dealing with the climate case. I think we can't ignore that fact. But at the same time, I think that these proceedings at the ICJ are very different from the klimasenioren case in ways that are maybe meaningful. First of all, the difference between an advisory opinion and a contentious judgment. There's not one state here that's being discussed in particular. There's not one state that's going to be held responsible for anything, and so that maybe avoids some of that poor little us, or we're being made an example of unfairly argument that we've seen in Switzerland. Of course, if the ICJ, makes findings that would lead towards a strong redistributive finding, I think there would be a lot of pushback. But at the same time, I think there's few ways to kind of guard against that, because klimasenioren was actually quite a measured judgment that left a lot of room to the state, and even so, the domestic reaction was frankly terrible. So, yeah, those would be my thoughts. But I'll keep it there because I think we have a lot more we can talk about. Thanks.
Yeah, if I can really quickly on that question as well. So I think on the legitimacy point, the fact that this was adopted, the questions were adopted by consensus at the General Assembly, and we had over 100 states participating, that already helps solve some of those questions, because states are clearly thinking that the court has the power to decide on those questions, and they are participating in this process. That being said, I don't think they're, as Corey was mentioning, they're going to go, on attributing responsibility, because it's beyond the objective of the AO. So I think that also will help evade those sort of concerns.
Great. So let me see.
Maybe let me jump in here, Yusra, because we did have a question early on. I think maybe before you were able to join. So and Caroline has mentioned this. So let's go to this from Veronica Botticelli, talking about how states' various positions on the existence of obligations towards future generations were addressed here. Do we see a significant shift towards a more inclusive approach to human rights as applied to future generations? And did the oral pleadings stick to expectations on this topic? So maybe we could go to that before working our way through the list. And as I sent out a note to everyone, we can keep the webinar open for about another 15 minutes to try to get to as many questions as we can.
Look, maybe Corey would like to go first on this. I've got things I'd like to say, but Corey, do you want to start?
Sure. Although I feel like, given your recent work, I think you're maybe one of the best people to speak to this question. But I would maybe say, in terms of expectations, if that's expectations of what we thought states were going to say, I think very often references to future generations, especially from high emitting or developed states, end up being so vague and so non-actionable that I wonder how much they actually mean. At the same time, we did see some very meaningful references to future generations. We saw discussions of the Maastricht principles on the rights of future generations. We saw arguments, I think, that really try to shift the state of the discussion that we have so far, and also kind of build on what other courts have done. So, for example, the European Court of Human Rights talked a lot about intergenerational burden sharing in its judgment. So, I think if I interpret expectations as my expectations, I think we have a lot of open questions around recognition of rights for future generations. I think maybe Caroline's recent argument that could be something that tailors the way the no harm rule applies is one way to kind of make this more practically tangible and meaningful. Maybe I'll let her speak for herself.
Yeah, well, thank you. Maybe I'll pick it up there and then we see if Danilo would like to add. I did think, that future generations obviously are important in these proceedings. I mean, they're mentioned a number of times in the question, and the court will be presumably considering what states have said and not said and how it can address this matter, which it needs to address. On the human rights side, there were certainly a couple of states, Germany and Russia, as I understood it, who said that I think they put it, the scope of human rights obligations requires currently living persons. So that was a fairly clear position. But there were many states who mentioned intergenerational equity. And then there were some great submissions on due regard for future generations. From St. Vincent and the Grenadines, we had, when it comes to states' obligation to protect the atmosphere from harmful greenhouse gases, it must have due regard to future populations. And that's a little bit like the IUCN submission that intergenerational equity requires due regard for long-term effects of states' conduct. And also pointing out that due regard for future generations is effectively recognised in the Nuclear Weapons Advisory Opinion. But yes, there could certainly have been scope for argument about whether, when you look at the interests protected by the principle of intergenerational equity and you look at the no harm obligation, use what is yours in ways that have regard for that of others, that future generations could well require to be considered in states' decision making around climate under the no harm rule as well. But just a bit of a mention too of the wonderful argument from Grenada and St. Vincent and the Grenadines as well, that states have fiduciary obligations to act as trustees of the climate system and future generations. And I love this argument. I have to confess that it is something that our recent doctoral graduate, Dr. Justin Sobion, has researched quite deeply, and he in fact spoke for both these states and put these arguments very powerfully to the court. So that was excellent to see, and we'll see what the court has to say. Thanks.
Very glad that there was a question about that. Another question from Francesco Sindico. Apologies if I missed this. Can I ask all panelists whether they feel that the 2 weeks we have just witnessed paved the way for future interstate dispute settlement, maybe even before the ICJ? Or does it pave the way for a reboot, a strengthening of climate change multilateralism under the Paris Agreement, or both? Danilo, would you like to?
Yeah, I can start. I can't see the written answer, so I'll just go based on what you just said. Yes, I think both, to be quite frank. On interstate dispute, I think the question by Judge Charlesworth in the end is already making way for that to potentially happen, when saying that essentially that the declarations of states on Paris not being enough. Sorry, the declarations of states when acceding to the Paris Agreement on the obligations there not being contradictory to their obligations under customary international law and other sources could come into play. And yeah, I think the question is how, if we're talking about ICJ cases, how do you ground jurisdiction for those cases, or will we go to arbitration? I think I'm not sure we're gonna see much on that in the judgment itself, but hopefully it will pave the way to some sort of dispute settlement, whether through international courts, tribunals, or through more flexible, yeah, dispute settlement arrangements.
Yeah, Corina.
I'd just like to maybe add that probably it will be both, but at the same time, we've seen so much disappointment and frustration from climate vulnerable states in the context of these proceedings when discussing the international climate regime. And from high emitting developed states, we've seen lots of calls for, the beauty and primacy of the Paris Agreement and the usefulness of cooperation and the fragile balances that have been struck that shouldn't be in any way troubled by judicial output. So I think maybe there are just two camps here, and probably work in both areas will continue. I do think, in the past we've seen that the sort of Paris architecture, and especially sort of the COP output documents, they do kind of, respond or at least pick up on what's happening elsewhere. So for example, after the UNGA recognized the right to a healthy environment, there's been a number of COP output documents that have mentioned the right to a healthy environment in their sort of general summary of human rights that are, vaguely, but not really a part of those documents. So basically, the human rights that are listed in the preamble of the Paris Agreement are no longer just listed as such, but the right to a healthy environment is also mentioned. So clearly, attention was paid to the fact that the UNGA had made this output, and so in that sense, I think there's always an interplay of these processes as well. That would be my 2 cents.
I'm happy to put 2 cents in as well. Thanks for the question, Francesco. So obviously the state responsibility side of this question is one that the court will be carefully navigating, knowing that there is certainly the possibility of contentious cases in future. And the issue of reparation under the law on state responsibility for damage caused through climate change is an absolutely massive question. When we think about what even a couple of small disasters in recent times have done to the world insurance underwriting market, and how thin the world's insurance arrangements are, and we think about the increase in severe weather events and other major episodes that will stem from climate change, states are really going to have to put their thinking caps on around the whole question of how our system of reparation in general, as set out in the law on state responsibility, can operate in this context. So that is a very big question. The role that perhaps probable even contentious proceedings could play in this will remain to be seen. Back in my mind, I was just thinking, as I thought about your question, is also the role potentially for strategic litigation. So are we likely to see spontaneous or even random potluck contentious cases, or are those who are considering taking contentious cases going to talk together and, in the way that we see sometimes in domestic litigation, adopt a sort of medium-term litigation strategy, thinking about not just the individual case, but how that case could play into the wider politics and legal development around climate change law and policy.
Thanks very much. I'm looking at the time, and although we do have some other questions, I'm not sure that I will be able to read them out for the panelists. I apologize, but I think that this was a really important webinar that raised some very important questions that we will keep discussing in other fora and in the months and possibly years to come. I'm very happy to turn it over to Mike for a final word before we close the webinar. Thank you so much.
Right. I just wanted to reiterate thanks to everyone, our panelists, for being able to join us today to talk through some of these issues with me and Yusra. It's going to be absolutely fascinating to figure out what the court does with this. And for those of you who might be on the webinar or even on the panel and are in some way implicated in trying to answer these very big questions that judges posed on Friday with a 1 week deadline to provide a comprehensive response, good luck. And it'll be really interesting to see what the court does with that and even how the court organizes the eventual advisory opinion that comes out, if it's organized around sources of law or different particular strands of the questions that can be teased out of the big overarching question. So I'm sure this is just the first of many events and discussions that will be taking place, as Yusra has said, over weeks and months going ahead as we reflect on the materials that have been submitted now. So thank you to everyone. And I also wanted, just in closing here today, give a special thanks also to our other co-conveners on the ESIL interest group, Cecily Rose, who is helping us out today, and also Stefan Wittek, because this is the end of their term on the ESIL interest group on international courts and tribunals. For those of you attending the webinar who are members of the interest group, you should have received information about the election that we're currently holding. So I encourage you to vote for the 3 new members who will be joining me and Yusra in the new year. But really thanks to Cecily and Stefan for all of their contributions to the interest group over the past several years. Thanks, Cess. And thank you to everyone for joining us and our panelists. Again, I hope it was a useful way to take stock of what we've just seen and the start of conversations going forward. Thanks very much and have a good week, everyone.
Thank you very much.
Thank you all. Have a nice rest of your day.
Bye-bye.
Thank you.
Bye.